Now we'll go to the last source of Hindu law, and that is custom. Custom is the parent of personal law in all countries, and India, a country with diverse customs, is not an exception to it. Custom is regarded as one of the most important sources of law, and custom in its legal sense means a rule which in a particular family, class or district has from long usage obtained the force of law. It must be ancient, certain, reasonable, and continuously followed. If it is in derogation of general rules of law, it must be strictly construed. In the leading case, that was Divyani Achi versus Chidambaram, a 1954 case of Madras, where it was held that a custom to have the force of law must be ancient, certain, and reasonable. It cannot be enlarged by parity of reason. A custom in derogation of Hindu law cannot be enlarged by parity of reasoning, but a custom which is either immoral or opposed to public policy or forbidden by statute cannot be recognized to be valid. So also in the particular case of Ramanand's case, which is famously known as Ramanand's case, there the Privy Council held that the modern authorities are equally emphatic on binding force of custom, as it remarked that clear proof of usage will outweigh the written text of law. To the same effect, also the Privy Council observed in the leading case Basant Rao versus Baji Rao that the commentators do not enact, they explain and are evidence of the congeries of the customs which form the law. So also the Judicial Committee in the leading case, that was Subhasini versus Nawab in 1941, a case of Lahore High Court, where it was expressed that it is understood and undoubted that a custom observed in a particular district derives its force from the fact it has from long usage obtained in that district the force of law. It must be ancient, but it is not of the essence of this rule that its antiquity must in every case be carried back to a period beyond the memory of man. And the same was held by our Supreme Court in the leading case I.Balwant and Pravin Kumari in 1958. So, in that case, the Supreme Court held a custom in order to be binding must derive its force from the fact that by long usage it has obtained the force of law. So, this was the very requirement that a custom to be valid, it must be ancient and antiquity, and it must not oppose to morality or public policy, and it is also not opposed to any statutory law. So regarding opposing of morality or public policy, we discuss now a leading case, and that leading case is of Balaswamy versus Balakrishna of 1957, a case of Madras High Court, and here it was held that a custom may be clearly established, it cannot be enforced if it is immoral or if it is against public policy. So, in the same way, in another important leading case of Bombay, that was Radha.ii.Hira versus Radha, 1937 of Bombay High Court, it was held that a custom whereby a temple dancing girl is allowed to adopt a girl with the intention of training or of an immoral profession, so it is invalid custom. And in the same way, custom must not oppose to statutory laws, and if they opposed, it could be not be given effect. And one important leading case, and that is of Abraham versus Abraham of 1863, the Privy Council held that a mere agreement among certain persons to adopt a particular rule cannot create a new custom binding on others, whatever its effect may be upon themselves. So, custom must be ancient, must have been long usage, and it must have antiquity. So also, it must not oppose to morality, public place, policy. It must be reasonable, and it must not oppose to any statutory law, neither agreement among certain people or persons. They could not create a new custom. It may be binding over them, but it could not be binding over others, whatever its effect may be upon themselves. So, these are the very important different sources of Hindu law, as we have discussed from the very beginning of Shrutis, Smrutis, commentaries, and digest judicial decisions, legislation, equity, justice, good conscience, and overall, the last one is relating to custom.